Welcome to The Debate. Our focus today is on the complex and, frankly, alarming intersection of national security surveillance and domestic activism. This is all drawn from recent material detailing the FBI's monitoring of private communications. Specifically, we're looking at a joint situational information report that was distributed across U.S. law enforcement agencies. It concerns a private Signal group chat used by immigrants' rights activists who are organizing these Courtwatch efforts in New York City.
Right, and this material really sets up a fundamental conflict for us to analyze. When does intelligence gathering, which is aimed at preemptive security, cross the line and become an unacceptable act of surveillance that actually criminalizes lawful civic engagement?
Exactly. The core question here is whether the FBI's decision to use a sensitive source to monitor an encrypted channel and then their subsequent labeling of the participants as anarchist, violent extremist actors was a necessary intelligence-driven response to specific credible threat indicators. My position is that the intelligence gathered, particularly its granular nature and its source within an encrypted channel, justified the heightened security posture and the issuance of that warning report.
And I come at it from a different way. I find the evidence that the FBI provided to be wholly insufficient to warrant the surveillance of what is, at its core, lawful, nonviolent activity. This represents, to me, an unacceptable pattern of using powerful national security tools like embedded human intelligence to chill constitutionally protected speech and, public accountability efforts.
Okay, well, let me start by outlining why I think this action was justified under the FBI's primary function, which is threat assessment and prevention. The August 28, 2025 Joint Situational Information Report, it wasn't distributed lightly. It was sent out as a warning about identified extremist actors targeting law enforcement officers in federal facilities. And crucially, the report cited specific threat language that was derived directly from within that private, invite-only Signal group.
What was that specific threat language, though, and how reliable was the assertion?
Well, the report cited an unidentified individual in the chat who was, and I'm quoting here, known to instruct protest participants to use violence against law enforcement. Now, that taken alone is an undeniable, credible threat indicator that requires immediate preventative action. But the justification goes deeper. The activity being discussed, even under the facade of court watching, suggested intelligence gathering that went far beyond just, simple public observation of a hearing. The debrief session, which was held via a Signal call with the embedded source, focused on collecting critical information, which included explicit details, photos and videos of law enforcement officers, specifically targeting their badges, their faces, and license plates, as well as detailed images of the interior of federal facilities like 26 Federal Plaza, 201 Varick Street, and 290 Broadway. That level of targeted collection of personnel and infrastructure intelligence, while it warrants a heightened security posture, regardless of the group's general stated purpose.
I see why you think that, and I do acknowledge the FBI's mission of force protection. However, I find that approach fundamentally misrepresents the context of the activity. Observing immigration court hearings is a lawful, nonviolent act open to the public, and it serves as a necessary check on government power, as Comptroller Brad Lander noted. The surveillance of a group engaging in this transparency work represents a fundamental attack on legal constitutional behavior. The FBI's action here is rendered suspect precisely because the report fails to provide any specific, verifiable detail to substantiate the highly inflammatory claim that the group members were anarchist violent extremists, or that the identified individual had previously called for violence. The absence of specific evidence forces us to challenge the whole premise.
But the intelligence was gathered privately via an embedded, sensitive source, human intelligence, which entirely changes the risk calculation from simple public observation.
It certainly changes the risk calculation for the activists, who now realize their private encrypted discussions are compromised. Look, we can't ignore the context here. ICE has been escalating the detaining of immigrants at courts, which an Associated Press investigation called deportation traps. So the Courtwatch efforts are therefore a necessary legal defense mechanism to ensure transparency and due process. The surveillance, consequently, it targets efforts to obtain basic accountability in a really politically charged environment. As former DHS Intelligence Counsel Spencer Reynolds pointed out, this fits into a disturbing historical pattern of the U.S. government criminalizing free speech under the pretext of national security.
Okay, let's delve into that primary point of contention then. The credibility of this extremist label versus the legality of the physical activity.
I challenge the institutional power of the extremist classification when it's applied without any public evidence. The actions described in the material, even instructions on where to go and what to say to gain courtroom access, that is standard civic participation meant to ensure public access to the judicial process. Without concrete, actionable evidence of imminent violence or a conspiracy to commit violence, applying the label anarchist violent extremist actors to lawful activity serves only one purpose: to delegitimize and intimidate. Bradlander condemned the tactic, calling it ripped straight out of the J. Edgar Hoover playbook. We have a long history of the FBI using these exact tactics, labeling political dissenters as threats to justify infiltration and disruption.
I acknowledge the dangers of historical abuses and, of course, the importance of civic participation, but the context of this report is prevention. Intent has to be assessed, especially when federal personnel and infrastructure are the focus. We're dealing with private, encrypted discussions accessed via a sensitive source with excellent access, which provided critical intelligence suggesting malicious intent that, it supersedes the public nonviolent facade. The crucial evidence here is the nature of the data they were collecting. The group specifically discussed collecting detailed media of law enforcement officers, including badges, faces, and license plates, and, significantly, detailed photos of the interior and security procedures of federal facilities. That moves beyond documentation for public oversight and becomes, definitionally, intelligence gathering for force targeting.
I'm just not convinced by that line of reasoning. Gathering information on officers is often a standard response to perceived abuses or, efforts to document potential civil rights violations in a highly sensitive environment where arrests are being aggressively executed. The line between accountability documentation and operational intelligence is not nearly as clear as you frame it, especially when federal agents are perceived to be operating outside procedural norms. Furthermore, the true weakness of the FBI's claim is exposed by their refusal to substantiate the label. The FBI explicitly declined to respond to inquiries seeking specific examples of violence or evidence to support the extremist labeling. This lack of transparency suggests the classification itself is speculative, if not outright pretextual. Dr. Ryan Shaper pointed out that basic civic participation is being treated like a terrorist threat. If the threat was truly imminent and credible, why the opaqueness? Why not pursue criminal charges instead of just issuing an intelligence warning?
Well, we have to distinguish between the standard of evidence required for a criminal indictment and the standard required for an intelligence report. The Joint Situational Information Report, it operates at a lower threshold because its purpose is preemptive security and threat neutralization. It's designed to warn agents before an event occurs. Waiting for criminal-grade evidence, which would require sacrificing the source, potentially exposing agents, and waiting for an act of violence to begin, it defeats the entire purpose of prevention. The opacity is often necessary to protect the source, who had excellent access and was embedded in an encrypted channel.
Protecting the source is standard operational procedure, I get that, but that doesn't mitigate the systemic damage caused when the intelligence gathering process itself becomes the tool of political suppression. The low threshold you described for this JSI report is precisely why we have to scrutinize its application against political organizing. The power to simply label a group as anarchist, violent, extremist actors without public verification is an immense institutional power, and it's capable of chilling democratic participation instantly. It allows the FBI to justify surveillance retroactively by using inflammatory, unsubstantiated language.
Okay, let's shift to the operational challenge, which I think highlights the necessity of the methods used: the access method, the encryption, and the oversight. The FBI successfully accessed a signal chat, which is known for its robust end-to-end encryption. The fact that the FBI secured information from a sensitive source with excellent access, it demonstrates necessary operational effectiveness in infiltrating these high-value, protected communication channels to counter what they believed were specific, targeted threats against federal infrastructure and personnel. This isn't passive data collection, it's proactive human intelligence responding to specific alleged threat indicators.
While I understand the operational drive for effectiveness, I'm sorry, but I just don't buy that the operational success justifies the policy cost. Let me tell you why. We have to consider the severe implications of accessing private, encrypted chats that are widely used by activists, journalists, medical professionals, and vulnerable communities precisely because they rely on that protection for their safety and privacy. The successful infiltration of a robust E2E channel like Signal, even if it's through an embedded source, it sets a damaging precedent. FBI surveillance of this nature, it's not subject to the kind of significant oversight that a FISA warrant or a traditional Title III wiretap would require. This creates a massive risk of a chilling effect, profoundly undermining trust in private discussion environments. This isn't just about this one group. It's about signaling to any grassroots movement that uses modern, secure communication that their private discourse is susceptible to being weaponized by national security agencies.
I think we have to differentiate between historical, broad-based surveillance programs and targeted counter-extremism operations today. The source material indicates the FBI wrote that the source participated in a debrief session held via a signal call, which strongly suggests an embedded source operating under very targeted parameters. This specific method of infiltration points toward an investigation that was triggered by prior indicators of threat, not some kind of phishing expedition designed purely to intimidate dissenters. Moreover, the argument that documenting agent activity is simply oversight, it ignores the specificity detailed in the report. The instruction to photograph the interior layouts of secure federal buildings and to collect personnel data, badges, license plates, that goes beyond simple observation of a court hearing. We need to focus on the line where lawful observation transitions to counter-surveillance designed for targeting. And it seems to me that line was clearly crossed in the intelligence that was collected.
That's a compelling argument regarding the specificity of the intelligence, but have you considered the broader policy implications? Spencer Reynolds compared this activity to past FBI efforts, specifically the infiltration and disruption of the civil rights movement under COINTELPRO and the widespread spying on Muslim communities post 9/11. The tactic of using embedded sources to generate intelligence reports on political dissent is institutionally dangerous. The very fact that the agency is using HUMINT, the most intrusive tool in the counterterrorism arsenal, against individuals engaged in court observation when no criminal charge followed, highlights a severe misuse of power.
Well, the intelligence report itself is the tool of threat neutralization, and that leads us directly to the context and how this interacts with the rule of law and due process. You argue that this surveillance can't be separated from the context of aggressive ICE enforcement.
Absolutely. The practice of court arrests, these deportation traps, was restricted under the Biden administration precisely because it interfered with the fair administration of justice. Court watching emerged as a direct, necessary response to the fact that DHS had created this enforcement climate. By surveilling the activists who are providing this oversight, the FBI is turning powerful national security agencies against critics who are merely standing up for the rights of immigrants and for transparency. This fundamentally threatens the rule of law by insulating the government and its agents from public accountability and documented scrutiny.
I'm not convinced by that line of reasoning because the intelligence report's focus was clearly on force protection. The FBI's mandate is protecting federal agents and facilities, not interfering with the immigration court process itself. The material is explicit about this. The concern was extremist actors targeting law enforcement officers in federal facilities. While court observation is legal, the FBI's concern was focused on the potential for individuals to use the cover of legal observation to gather intelligence for harmful actions, especially given the alleged instruction to use violence that was circulating in the private encrypted chats. You're conflating two issues, I think. The merits of ICE policy, which is debatable, and the security threat presented by individuals who may be exploiting the court-watching activity for malicious ends. The intelligence gathered, specifically filming facility interiors and collecting badge numbers for targeting, is entirely separable from the merits of transparency, and it justifies the FBI's preventative action.
But they are gathering data on agents because the agents themselves are acting aggressively in a sensitive environment, potentially violating due process rights and creating a climate of fear in the courts.
The FBI is essentially saying that efforts to document the conduct of federal agents in public facilities, the very definition of accountability, can be elevated to a terrorist threat if the people doing the documenting are deemed extremist by an anonymous source. If the FBI wants to uphold the rule of law, they need to provide evidence that this group moved beyond documentation into actually planning violence. Absent that evidence, they are leveraging national security power to suppress political criticism.
The evidence is in the operational focus of the intelligence gathered. Why would you need blueprints of the interior of 26 Federal Plaza unless you had malicious intent? The intelligence indicated a credible, non-public threat of violence against law enforcement officers in federal facilities by actors who are labeled extremist. Based on the specifics of the data collected by the sensitive embedded source, including that highly granular information on personnel and facility interiors, the FBI's issuance of a warning report was a justified preventative security measure focused on force protection and threat neutralization.
And conversely, when surveillance targets legal, nonviolent civic participation, activity aimed at accountability and transparency, and the law enforcement agency fails entirely to provide any publicly verifiable evidence to support its claims of anarchist violence, the action constitutes a profound violation and the criminalization of protected speech. The lack of transparency and evidence strongly suggests the primary goal is intimidation, risking a deep and lasting chilling effect on fundamental democratic freedoms and the right to criticize government action.
What this material ultimately illuminates is the critical tension between two necessary imperatives. We have legitimate national security concerns requiring effective targeted surveillance methods to protect personnel and infrastructure, which must be weighed against the absolute necessity of protecting constitutional rights, especially the right to dissent and assembly.
And it forces us to scrutinize exactly where legitimate security concerns, operating on a low threshold of evidence, end, and where the criminalization of dissent begins. This tension is amplified when powerful agencies use opaque surveillance methods and highly charged, unsubstantiated language like extremist to describe lawful accountability efforts. The material really demands further scrutiny into the operational and policy cost of infiltrating secure channels used by activists.